Hello, my name is Ashley Strauss Martin, and I'm the attorney for the Realtors Association of New Mexico. I'm here today to talk to you about the revised Residential Purchase Agreement, RANM Form 2104. Today we will be talking about the next section of the revised purchase agreement. Let's begin with paragraph 6. The previous paragraph 5D, entitled Contingent Sale, has been modified and renumbered, and it's now its own paragraph, paragraph 6. It begins at the bottom of page 3 and continues on to page 4. This section has been significantly modified. There is now a space to enter the buyer's property address and the date by which the buyer's property must close. 2 subparagraphs have been added as options. The parties are to choose the applicable paragraph. In the first, the buyer represents that his property is under contract for sale, and the parties have the option of attaching the newly created RANM Form 2503, the buyer's closing and funding addendum, a short 2-page form. In the second subparagraph, the buyer represents that the buyer's property is not yet under contract for sale, and the parties are given the option of attaching RANM Form 2503, the existing buyer sale contingency addendum. It is important to note that for those brokers representing buyers, checking the first box indicating the agreement is contingent on the closing and funding of buyer's property will be enough to create the necessary contingency. The buyer will not be obligated to close on the new property if his property does not sell, close, and fund by the date specified. However, for those of you representing sellers, be aware that simply checking and completing the buyer's contingency option in the purchase agreement without attaching the applicable buyer's contingency form will not provide the seller with the same protections as he would receive if the applicable buyer's contingency form was attached. For example, the existing buyer sale contingency allows the seller to market his property up until the time the buyer's property goes under contract. And if the seller receives another offer on his property, it allows the seller to demand that the buyer satisfy or waive the buyer sale contingency, usually within a short time frame, whatever time frame has been agreed to by the parties. If the buyer is unable to do so, then the seller may accept the second offer. This is clearly to the seller's benefit. The seller will not have such an option if the buyer's sale contingency is not used. Also, in the new buyer's closing and funding addendum, the buyer is required to disclose and warrant information about the sale of his property and to notify the seller should the sale fall through. Again, this is to the seller's benefit, and the buyer has no such obligation if the buyer's closing and funding contingency is not used. Since buyers will be completing the purchase agreement, sellers' brokers will need to pay special attention to this section and determine if a buyer's contingency has been attached. If the offer does not include an addendum, the listing broker should discuss and review the applicable addendum with his or her seller to determine if the seller wishes to counter the offer using the applicable addendum. Paragraph 7 is the new appraisal paragraph. While both the language and formatting have been changed, the contingency is similar to what is currently in the purchase agreement. Paragraph 7A addresses cash and seller finance transaction and allows the buyer to indicate if he wishes to have an appraisal conducted. The buyer selects the appraiser, unless otherwise agreed to in writing, and the parties choose who shall pay for the appraiser. Buyer's initials are required in this subparagraph. Paragraph 7B is the appraisal contingency and applies to all conventional and non-conventional FHA VA loans requiring an appraisal, cash and seller finance purchases if the buyer has selected that he wants an appraisal in paragraph 7A above, and to all FHA VA loans unless the buyer has received an appraised valuation from one of the listed entities stating that the value of the properties is not less than the purchase price. Paragraph 7C explains what options the parties have in the event the appraisal should come in below the purchase price. 7C1 says the buyer may elect to proceed with the purchase if he notifies the seller of such an election within 3 days of receipt of the appraisal. If the buyer fails to notify the seller, the contract automatically terminates. Or 7C2 says that the parties may negotiate a new purchase price. If the parties can't come to an agreement on a new purchase price within 5 days of the buyer's notification to seller of the appraised amount, then the contract will automatically terminate. Or 7C3 says that the buyer may terminate the purchase agreement without penalty. Note that while the language in subparagraph 7B3 and some of the language in 7C1 may sound a bit verbose, it's language similar to that in the FHA and VA subsections of the appraisal paragraph in the previous purchase agreement, and it is language required by FHA and VA. Paragraph 8. The title paragraph and paragraph 8A have no significant changes. In paragraph 8B, a sentence was added at the end of the first paragraph to clarify that the seller must provide keys, codes, and gate and/or garage door openers to the buyer on the funding date. Also, at the end of the second paragraph, a sentence was added to clarify that if the buyer's lender fails to make funds available by the funding date, the buyer is in default of the agreement. The buyer and seller must remember that they are the only parties to this agreement. Neither the brokers, the inspectors, the lender, the title company, appraisers, nor anyone else is a party. Therefore, when something is supposed to happen in the agreement and it doesn't happen, it is attributable to one of the parties to the agreement, either the buyer or the seller. In this case, the language was added to remind the buyer that if the buyer's lender fails to do something, that failure falls on the buyer and places the buyer in default of the agreement. Paragraph 9, entitled Possession Date, underwent no significant changes. Paragraph 10, Cost to be paid. A new section was added to the Cost to be paid box. It's entitled Manufactured Home Cost and includes 4 specified items and boxes where the parties can add other costs. Also, escrow fees have been taken out of the box. Paragraph 11, IRS 1031 Deferred Exchange, and Paragraph 12, Prorations, were not changed. Paragraph 13, the assessment paragraph, has been modified. First, it clarifies that if the property is located in a public improvement district, the seller must provide a public improvement district disclosure to the buyer before accepting an offer from the buyer, and the public improvement district paragraph, paragraph 17b, is referenced. For all other bonds, assessments, and fees, the buyer has a certain number of days after receipt of the title commitment to object to such assessments or fees. The parties must fill in the number of days that the buyer has to object. If the buyer fails to timely object, then the buyer will be deemed to have accepted the assessment or fee. Paragraph 14, Examination of Titles, Liens, and Deed. The only addition to this section is in paragraph 14c, where the option of special warranty deed was added. It is important to note that we have added a definition of standard exceptions. It can be found in paragraph 27, subsection O, and states that the term standard exceptions means those common risks as set forth in the title commitment for which the title insurance policy does not provide coverage. These printed exceptions are matters outside the title company's search of the public record, and therefore special requirements must be met in order to delete them and provide the insured with the additional extended coverage. Paragraph 15, the FIRPTA paragraph, was modified. This paragraph no longer creates a contingency as it did in the previous purchase agreement. The first paragraph of this section provides a synopsis of FIRPTA and references the FIRPTA information sheet, RANM Form 2304, for additional information, much like the FIRPTA section in the current agreement. The second paragraph addresses the most common exception to FIRPTA, that the sales price of the property is $300,000 or less, and the buyer is using the home as a primary residence. The buyer indicates with initials if the exception applies. And in indicating that the exception applies, the buyer is warranting that he will be using the house as a primary residence. This paragraph replaces RANM Form 2303B, the buyer's FIRPTA certification. If the exception does not apply, then in the last paragraph in the FIRPTA section, the seller agrees to provide the buyer or qualified substitute, which is most often the title company, with a non-foreign seller affidavit. And in the event the seller fails to do so, this paragraph authorizes the buyer to withhold 10% of the amount realized from the sale of the property at closing for remittance to the IRS. In addition, the FIRPTA acknowledgement box that was on the last page of the previous purchase agreement has been eliminated. Paragraph 16, the insurance contingency and application paragraph, has been reformatted, but not significantly changed in content. The only noteworthy change is that a provision was added that states that the agreement is also conditioned on the seller's claim history having no impact on buyer's insurance in the future. This was added because the only contingency that previously existed was that the buyer be able to obtain insurance, quote, at a normal and customary premium rate. But there are times when the buyer can obtain such a quote, but could lose coverage with the submission of only one claim due to the seller's insurance claim history. Paragraph 17, entitled Disclosures and Documents, was significantly amended. All of the disclosures that were boxes in the current purchase agreement have been moved into paragraphs under this heading. Lead-based paint, public improvement districts, homeowner association, property tax disclosure, septic systems, and wells. A subparagraph on manufactured housing was added. Note that all the subparagraphs under this section require yes or no answers. In addition, the PID subparagraph, paragraph 17b, requires that the buyer acknowledge receipt of the PID disclosure by initialing. The initial requirement is new. In addition, the property tax disclosure subparagraph, subparagraph 17d, requires the buyer to acknowledge receipt of the property tax disclosure or the fact that the disclosure is unavailable by initialing. Again, this requirement that the buyer initial is new. The inspection paragraph, that is the previous paragraph 16B, has been moved to its own paragraph 20 in the revised agreement. We'll review that section in a moment. The grid begins at 17H. Certain manufactured housing documents are now included on the grid. Paragraph 18, entitled Surveys or Improvement Location Report, was previously subparagraph C of paragraph 16. It's now its own paragraph 18. The grid has been replaced with a paragraph with various checkboxes and subparagraphs where the parties enter delivery, objection, and resolution deadlines specific to this section. Paragraph 18D states that paragraph 20H and I of the inspection paragraph will govern buyer's objections to the survey or ILR and resolutions to the buyer's objections. Paragraph 19, buyer's representation. This buyer's representation paragraph is a new paragraph and should be thoroughly reviewed. Previously in the purchase agreement, we encouraged the buyers to investigate the neighborhood, but also previously in the purchase agreement, we provided no out for the buyer in the event that they found something in the neighborhood that they didn't approve of. This began a discussion about whether the contract should provide an opportunity for termination if the buyer found out there was an issue in the neighborhood of which he didn't approve, such as a registered sex offender living nearby, or a barking dog next door, a waste transfer station around the corner, or the fact that the property was in the flight path of a nearby airport. The committee consensus was that the buyer should investigate the neighborhood before making the offer. This paragraph 19 alerts the buyer to that fact and requires the buyer to warrant that he has done his due diligence in regards to the neighborhood and surrounding areas before making the offer. Brokers should note that even if the agreement is amended to delete this paragraph, there is no contingency in the agreement that allows a buyer to walk away from this contract if the buyer learns of something in the neighborhood or the surrounding areas that he or she does not like. Paragraph 20, inspections. This is paragraph 16B in the previous purchase agreement. A couple of sections have been modified, as I will note as I go through each subsection. Paragraph 20A1 sets forth buyer's duties and rights to investigate the property and to assure that he is buying what he thinks he is buying. Paragraph 20A2 alerts the buyer to the fact that he has the right to conduct all inspections of the property that he hasn't otherwise waived. Paragraph 20A3 advises buyer to thoroughly investigate square footage if square footage is an issue to the buyer and requires that the buyer initial this subparagraph. Paragraph 20B explains that the seller has a duty to disclose material defects in the property, but is not responsible for correcting those defects. Paragraph 20C allows the parties to choose who will be responsible for paying any charges required by the utility companies to have utilities turned on for inspection purposes. The language in paragraph 20D is similar to the language in the previous paragraph 16B and states that the buyer will select all inspectors and order all inspections unless otherwise agreed in writing, and that the seller does not have the right to choose the inspector just because the seller is paying for the inspection. Paragraph 20E, payment of inspections, paragraph 20F, inspection deadlines, and paragraph 20G, waiver of inspections, use the same language as in the previous paragraph 16B. They have just been renumbered so that each section has its own subparagraph reference now. Paragraph 20H, buyer's objections, is essentially the same language as in the previous paragraph 16D. The concepts have been broken down into two additional subparagraphs to make the paragraph easier to read. In the last subsection, paragraph 20H4, it now states that buyer may use RANM Form 5109, the objection, resolution, and waiver amendment to the purchase agreement, to make his or her objections. Paragraph 20I, resolution, has been amended to set forth additional options in the event buyer makes objections. The seller may agree to buyer's requested cure or provide an alternative cure or refuse to correct or address buyer's objections. This is not new language, but it is important to be aware of what happens if there's no resolution to the buyer's objections by the resolution deadline. If the buyer makes objections and the seller does not respond to those objections by the resolution deadline, this contract will automatically terminate. So if the buyer still wishes to purchase the property, even if the seller is unwilling to remedy the buyer's objections, then as the resolution deadline approaches, the buyer should be pushing for resolution. But if he or she does not receive resolution by the deadline, he or she needs to reconsider and consider withdrawing those objections by the resolution deadline so that the parties remain under contract. Also, there's now a definition of the term resolution in the definitions paragraph, paragraph 27. Resolution means the buyer and seller have a written agreement regarding how all buyer's objections shall be resolved. Paragraph 20J, objections completion, and K, reasonable access, damages, are the same as paragraphs 16G and I in the previous purchase agreement. The language has not changed. Paragraph 16F in the previous purchase agreement, entitled Cost of Repairs, in which the seller agreed in advance prior to inspections to pay so much toward the cost of repairs, has now been deleted. Paragraph 21, Home Warranting Contract. The introductory language has been modified slightly, but conceptually has not changed significantly. However, following the introduction, there is now a space to enter several pieces of information. First, the parties must choose who will order the home warranty contract. Secondly, the parties must enter the name of the home warranty company from which the warranty will be purchased. Thirdly, the parties must agree on the maximum cost of the home warranty contract. And lastly, the parties must agree on who is going to pay for the home warranty contract. In the event the buyer is electing not to purchase a home warranty contract, then the buyer needs to affirmatively elect by checking a box that he does not want a home warranty contract. That concludes our presentation on this section of the revised purchase agreement. If you have questions on this section, please feel free to call me on the legal hotline. The number is 1-800-699-7266 or email me at legalhotline@nmrealtor.com. Thank you.